So, good evening, everybody. I'm Carl Finger, Associate Counsel. I was asked to give a little talk tonight about leases, renewals, preferential rents, and things like that. Some of you may be well aware of these issues, others not. I was asked to keep the talk to 3 minutes or less, so it's going to be extremely concise. It's going to be a little more than 3 minutes, but and then what I'll do is when I'm finished, open the floor to questions, and I'm happy to take questions about any subject, even if it wasn't this specific subject. But I'm going to try and give you some tips, some background about, especially about preferential rents and how we got where we are today, how we got there, and a few tips on things you should consider with leasing. Many of you may already know, but maybe it'll be a little helpful. I'm going to try and operate the machine. Okay. So, anybody here a tenant before I start? Just making sure. Okay. So, first thing I thought was, well, what are we talking about, right? You have to know what's going on the other side. So, I found one of the main groups in Westchester, you may know, Mount Vernon United Tenants. You don't need their address, but just so you recognize it. They're having a meeting this week on Wednesday with legal services. Know your rights, basic eviction prevention and fair housing preservation for the community. So that's what's going on right now on the other side. And legal services, here's legal services, those are some of their supporters. In case you see them, you can, well, I don't want to tell you what to do.
I see a former member of ours.
This is their board. I don't know who's former. But in any event, I thought what was interesting about their promotion with legal services was it says this training is designed for tenants or prospective tenants. So I thought that was great. You're not even a tenant yet, and they're telling you what to do as soon as you sign that lease. So they're out there, promoting how tenants can protect their rights, and frequently that is not going to coincide with your rights. Let's put it that way, as landlords. So it's not always, who's going to be on the opposite side, but, when you're talking about legal services, when you're talking about Mount Vernon United Tenants and other organizations like that, for the most part, it's different sides from us. Okay, so with that in mind, since they're preparing before they sign the lease, you should be preparing before you sign the lease also. And that means having a good, strong, landlord-oriented lease. There are a number of different forms out there. Most of you probably already have one that you're comfortable with. I'm just going to review a few important provisions that you might want to look at. And you just want to make sure that the lease you're using protects you. And there are enough good leases out there for you that should not be a problem. But every once in a while, somebody comes to me, a landlord, and they hand me a lease, and it's, a god-awful lease, and nothing good happens if you don't take preliminary steps even before you have a tenant to make sure that you're protected. So, residency, who can live there? The first thing is you'll hear about the roommate law. The roommate law means that your tenant is allowed to have a roommate, basically, but not unlimited roommates. So there are 3 scenarios which I pictured here. The first one is, the tenant and 1 friend. So that is clearly covered by the roommate law. On the far end of the spectrum, you have the tenant plus 3 friends, right? So that may not be something the tenant can do. Oftentimes, the law says a roommate, and there are some cases that will support the idea that they can't just bring in more people. There's a lot of good reasons why, as a landlord, 1 other person might be something that's more tolerable than 3 or 4 or 5 or however many. And then in the middle, I put the family, because the family issue gets complicated, whether they bring in family or whether they... there was a particular case in Long Island, the landlord was ATM, some company ATM. And ATM 1, ATM 2, they have all different, iterations, and they're not afraid to go to court, and they're not afraid to lose, apparently. So they went to court to evict this family because they had more kids, and they said now it's too many people. And the court, not wouldn't surprise anybody, I would think, wonder, well, we're not going to evict people because they gave birth and had a bigger family. So, you know, there's times to maybe, you know, think twice. Use, residential only. So I'm mainly talking about residential here. If we wanted to do commercial leasing, that would be, you know, a whole different ballgame. We're talking about apartments, so only residential. Most leases will have a clause that says residential. That's typically enforceable. It is a little more difficult today with certain, you know, in-home businesses where people are running something from the internet and things like that. However, we have been able to deal with tenants who are running businesses where there's traffic and where they're parking cars and things of that nature. Well, for instance, the one I'm thinking of, we had somebody who was running like a chauffeur service, a limousine service. Now, they said, well, we're doing it online, it's on the computer. And there were 2 cars that they had parked that were taking up 10 parking spaces, and we were able to get them evicted as a result of that. Obviously, I think you're making the same point I, we get to these online businesses, and it may be harder to really...
Airbnb is what I see.
Oh, Airbnb is a different issue. I think it's not just the running of the business; it's the use of the apartment. So actually, going back to my prior slide, it says residential. It says roommates, right? That presumed, I should clarify, it presumes that you're living there. If you're not living there, then you'll have potentially no subletting clause and a failure to comply with the occupancy clause, which says you're going to live there. So I think there should be protections against Airbnb for sure. If you don't have anything, I think most leases, the boilerplate will have clauses that will protect you. But if you're not sure, it never hurts to draft something or get your lawyer to draft something specific.
But you can live there, and this weekend I'm going to rent it out, and I'll go somewhere else.
Or even more difficult is the Airbnb where you're living in one room and renting out another room, and you have a roommate. And that's a really tough one, if the person's actually there. And I don't know that if the person's living there, it's going to be very difficult to get them out from renting the room because of the roommate law, unless they're renting to 2 other people. And then we get back to what I said on the prior slide.
Just a question. When you have those subleasing on the lease, and don't we add to if someone says, I want a sublease, and they come, you know, they are
Yes.
Oh, just repeat it.
So the question, right, so the question is about subleasing or assignment of lease. There are some specific provisions in New York State where if a tenant comes in and says they want to sublease it, if they comply with the provisions under New York State, I don't remember the section of law offhand, but that you would have to give them the ability to do that. That having said, most of the tenants don't really comply with what the law requires in the first instance. You know, there's certain technical things they have to do. So, but yes, that's a fair point. You should be aware that if they do comply with the law, you might be required to allow them to sublease it for a period of time. I don't remember off the top of my head. So a few other, you know, basic. Sure.
I'll ask you to take on.
Okay. Rent, you want to make sure it's payable in advance. That way, when you get to the 3rd of the month, you can hit them with a 3-day demand. At 2nd of the month, even if you have a problem tenant, you want to be able to go after them right away. You want to make sure you have an additional rent provision, which says that if there are other fees that they incur, like legal fees, etc., that those become rent and are collectible as rent. And there's all kinds of issues in court, but some courts will affirm that, and they will give you more rights to collect the funds that you're due. If it's a rent stabilized lease or an ETPA lease, you have ETPA in Westchester, rent stabilization in New York City. Sometimes there are adjustments by DHCR if you have a major capital improvement or something like that. If you have that type of tenancy, you want to have a clause in your lease that allows you to charge those when DHCR approves them. Security deposit clauses and conditional apartment. I mean, you want to get at least one. Generally, you're going to get at least 1 month. There may be occasions you can or would like to get more than 1 month. Conditional apartment. You want to be specific about And most leases have this, you know, the condition of the apartment at the end of the lease, reasonable wear and tear, but also you want to have something about they're accepting the apartment in as is condition, etc. I'm going to note, consider photographs. The idea being if you photograph it at the beginning of the tenancy, you have pictures, then at the end of the tenancy when they move out, and you know the walls are a big mess, and they've taken out a TV thing that they had attached to the wall with giant holes, the carpet's ruined. The photographs really, really help in court. Because no matter how much you try to describe it, it just doesn't, you know the saying, I don't need to say it out loud. Yes?
How about succession rights on rent stabilizations?
I could do an entire course on succession rights. So the question is, how about succession rights? I mean, how about them?
The limitation of
You get
occupancy.
one as a limitation of occupancy?
How long do they have to be living together to obtain it?
Generally 2 years. So if a family member, a non-traditional family member lives in a protected tenancy, an ETPA tenancy, for 2 years, they can inherit the apartment. That's the rule of thumb.
They need to be on a lease, I assume, though, right?
They don't need to.
No?
But they need to establish that they were there.
Okay.
And that's where oftentimes the litigation ensues. You know, they say they've been there for 2 years, the landlord says they haven't. So you end up getting into a case where you have to get tax returns and driver's license and voting records and bills and things of that nature. There are some cases from DHCR, however, that say that if the tenant asks, if that person is living there, family member, and asks to be put on the lease, that the landlord should do that. Although I disagree with that and said that their succession right is not contingent on them being on the lease, that the landlord shouldn't have to put them on the lease. But there's a form, actually, that they can send to notify you that they're there. And if they send that form, it's, you know, it's difficult because they've done at least an initial step to show that they're there.
Could that form be attached to the renewal lease that gets out? And they have to fill that out on who's living there, how many occupants?
If you send out an attachment to a lease renewal asking who's living there, and the tenant signs it back and doesn't mention that her niece is living there, or her daughter or son, presumably that would be helpful to you at a later date. But I don't believe it would necessarily be determinative. A court would probably still look at where was the person really living, right? And if they could prove that they were living there, or you couldn't prove that they were living somewhere else, that's a fine line, right? I think you would have, that would not necessarily carry the day. But it can't hurt. I don't see how it could hurt.
Why would it favor the landlord? I mean, why would landlord want the tenant to fill out the form?
Well, the suggestion was if you give them, I think this, if I understood it correctly,
Yeah, when I
you give it to them and they don't fill it out. Right. The flip side of that is maybe don't give them the form because you're just giving them the opportunity to put a name down and then you're stuck with it. I mean, so there are a lot of different strategies, you know, to employ. The reality in that situation is that if you have if the person's living there and they move in ahead of time and they are there for 2 years and they can prove it, it becomes difficult.
Does that apply to roommates too? Does the roommate law carve that out?
No, roommate wouldn't necessarily be entitled to succeed if it wasn't some type of family member necessarily. Well, you know, we've gotten
I can't make
non-traditional.
You're right. Right?
Well, they have non-traditional family now, you know, partners and such. So it would be. I think the criteria, and this is why I was saying, could be a whole other thing. There's all kinds of criteria that they apply, and it's not just blood. It could be a godson, wouldn't be enough that it was a god necessarily to be that relation. So there's a whole other, you know, we could go on with hours on cases.
Carl, let me interject something, otherwise I'll forget it. You all know that we go through this annual passion play of the rent guidelines hearings. I think succession is one of the few areas where it can be documented by our owners of you know, basically the exercise of this divine right of kings that keeps the unit within the family or the relationship or whatever the heck you want to call it these days. And for all the highfalutin words of Westchester Hudson Valley Legal Services and Dennis Hanratty's group, succession is probably one of the single greatest reasons why so much affordable housing is denied to the very people who need the house. And I think that's a very powerful argument to make next year. If any of you have horror stories, I'm sure you must have horror stories about succession, that a unit that would have otherwise have gone in the natural progression of things as families earn more money and they go up and beyond to better housing, that succession actually robs probably thousands of units within Westchester from families who truly need the affordable housing. I think that's a very powerful argument, but only you all around the table can provide those details, because the tenants do it. The tenants have all these anecdotal stories, so we should counter with our own horror stories that have a profound social impact on the need for affordable housing. Anyway, I wanted to say that just to put that idea in your heads.
Okay, so let me just jump a little bit. Preferential rents, that was one of the critical issues that I was asked about. So I wanted to take a minute to kind of go through the historical evolution of preferential rents. The kind of first seminal case was the Collingwood Estates case in 1975. Before I was even studying landlord-tenant, believe it or not. And what happened there was the court ruled landlord charged a lower rent below. So you have a legal regulated rent, which is your rent plus your legal increases, etc. If the landlord decided they wanted to charge less rent, once that happened, that was it. That lower rent essentially became the legal regulated rent. Even if it was documented and kept separate and whatever, it was amounted to a permanent rent concession. So this was obviously, you know, bad news for landlords, and in some ways it wasn't great news for tenants if you think about it, right? Because it's a disincentive to landlords to rent at a maybe a more affordable rate if an apartment's available, because they know they're stuck. Even if the market in a certain neighborhood or whatever turns around, they're never going to get that back up to that market rent. So that stayed in place for a while. In 1987, there was a change in the regulations, and they said that when you have, at least when you have a new tenant, okay, new tenant and vacancy, you can now go back up to the legal regulated rent. So once you give a reduced rent to a certain tenant, as long as that tenant stays in the apartment, they have, you know, essentially a permanent rent concession, a preferential rent for that period of time. But once that tenant's out, new tenant comes in, you can bring the rent back up to the legal regulated rent. Presumably that would include any vacancy increase, long-term vacancy increase, or rent guidelines board increase. So that was a little better, right? And then we had the Missionary Sisters case. Missionary Sisters case was in New York City, and the court said that was an appellate division case, which is the intermediate appellate court in New York. And they said, look, if the parties agree in the lease that the preference is because of, for instance, current market conditions, then it doesn't have to apply to future renewals if those conditions no longer exist. So tenant comes in, the market's bad, we put in the lease the legal regulated rent, and then we put, well, the conditions are bad, we can't rent it right now, we'll give you a preference, we'll charge you, 20% less or 10% less for the term of this initial lease. When that lease was up, if conditions were better, you could raise the rent to the legal regulated rent, or something more than the preference but less than the legal regulated rent. You'd have flexibility, but again, you'd have to make sure that you put that information into that renewal lease. In 2003, the state basically adopted the Missionary Sisters as statutory law with some slight issues. So they passed the statute, they adopted the law, said if it's in the lease, basically, if you gave them a preference and then the market changed, you could take the preference away. Courts got a hold of this and kind of flipped it around and said, even if that's the case, if the lease or the writers of the lease did not explicitly state that the preference is going to end at the end of the lease or the renewal, that's it, it's still permanent for the term of that tenancy. So landlords who did it but didn't necessarily specify in a certain way were out of luck, all right? And again, they required that it has to specifically state that it's only available for that initial lease term or that specific renewal. So 2014, we had another year when the state amended the rent regulation statutes, and they said even more specifically, you have to say and this is really the crux of where we are today, in the lease or in the lease renewal, you have to say what the legal regulated rent is. Not just that they're getting not just that you're charging, let's say, $1,500 and it's a preferential rent, but you're charging $1,500, it's a preferential rent, and the legal regulated rent is $1,800 or whatever it might be. So that information, the tenant, they want to. It makes sense, if you think about it, that the tenant should know what the rent could go up to, right? So it's not terribly unfair in that sense, but it's very particular. You got to have it. And then the second thing, and this is maybe in a way the most important part of it. Many of you know about the 4-year rule that the statute says you only have to hold records. They can't go back more than 4 years for an overcharge complaint. That 4-year rule has a whole bunch of exceptions. Initially, we all thought, great, 4 years, you don't have to worry after more than 4 years maintaining records, et cetera, et cetera. One of the exceptions is right here. If you're going to give a preferential rent, you're going to have to maintain your records for more than 4 years prior to when the preferential rent was given to the tenant. And I guess the reason for that is so that they can see what the legal regulated rent was in case the tenant wants to challenge it, and they've been getting a preferential rent, and then you bump them up to the legal regulated rent, they would then need to challenge the legal regulated rent. The distinction being, if they came in on day 1 and rented the apartment at the legal regulated rent, presumably after 4 years, they've been renting at the legal regulated rent, they know what it is, so any challenge, presumably the 4-year rule would apply. So if they're getting a preferential rent, the court is saying you have to maintain your records. So probably a good idea anyway, to be honest, because of all the different exceptions now to the 4-year rule, but here it's specifically required.
Also, if an apartment becomes deregulated,
What was that?
an apartment is deregulated, became deregulated.
Oh, deregulated, yes.
2,700.
Yes.
And that's it, deregulated.
Yes.
Can the tenant still challenge us after a couple of years to prove that it was deregulated?
Well, yeah, I think you always have to be concerned about a tenant filing a complaint. And, if it's more than 4 years, you're protected from an overcharge, but you're not necessarily protected from the determination that the apartment was not properly deregulated. And that's where you can run into trouble. So.
Even though the apartment becomes deregulated, I still keep track of all the improvements and everything. So
Yeah, because if they come in 5 years and say, well, it never should have been deregulated, you want to be able to show that you did it properly, especially with the TPU coming in and doing all these audits and things of that nature. So some guidance generally when you're giving preferential rents. 1, specify the reason. That's from, obviously, the case law and Missionary Sisters. Number 2, specify that it's temporary, that it's only going to apply for the initial term of lease or the term of the renewal. Now, that doesn't mean if you do it during the initial term of the lease that you can't then give a preference for renewal to that lease. But it should be reflected also in the renewal that it's only valid for that 2-year or 1-year renewal. Don't assume that because you said it was temporary in the initial lease, that carries over. In fact, you should assume the opposite, yes.
How do you tell them in letter, by letter?
Well, so if you're, and I have a couple of forms up here, if it's you were talking about ETPA tenancies basically, right? So there's the RTPA form, and I believe there's a place where you can put lower rent being charged, and it will show it on there. I'll pull it up on screen in a second.
Will that work?
Well, you need a rider attached to that saying it's temporary. You have to have something saying it's a temporary preference. Did that answer the question? Sorry, I may not have answered the question.
Yeah, you got started on the road. Thank you.
When you register the rent, make sure you register at the higher legal regulated rent, because it's a problem. And not only that, now, it used to be you could amend the registration, you could file, in addition to filing it late, with the 2014 amendments, and this is one of the things that we, it might be 2014, anyway, regulatory amendments. This is one of the things that we challenged in Supreme Court against New York State with the Rent Stabilization Association in New York City. BRI and RSA, one of the issues was the ability to amend registrations, and DHCR has some language saying you can't amend it. So you make a mistake and they're saying you can't fix it, which is kind of ridiculous. But so you want to make sure that you register at the higher rent. And then, as I said, retain all the records relating to the preference and prior to the preference, so you don't get stuck. I did do.
I have a question
Yes.
about market conditions. Can it be a market condition that says that the unit itself wasn't up to snuff, it wasn't a great unit, and since then I redid the kitchen, or you made it a much nicer, more valued unit?
Well, first of all, I would say that I'd say that's possible, but if you're doing that while a tenant is in occupancy, you're getting the tenant's consent, hopefully,
Right.
and you're getting your 1/40th increase as well. Depending on the size of the building, 1/40th or 1/60th, thank you. You're getting your proper increase for whatever the improvement is. And you have to have the tenant sign off on it if they're in occupancy. I don't think DHCR has a form, but you can make a form and you just want to make sure they agree to it and add it into the rent. But I don't know, I'm not sure how that would come out 100%. You might be able to get away with it, yes.
Maybe kind of turn the question around. Has there been a lot of cases where the tenants have won, or it's been, voted in their favor, that there was no language in there about market conditions? Because the leases that I've seen, I don't see a lot of that. I just see the calculation in there, but not anything about market conditions.
There hasn't been, since the law changed to basically allow the preferences as long as it's in the lease, there hasn't been a lot of those cases. There were a lot of cases during that first round when they said, when they first said it, and then in 1987, there's a whole bunch of cases after that, and then the missionary sisters and the statute changed, and they came back around in 2000, whatever it was, 3. But there was a whole bunch of exceptions before that.
Carl, is it possible to get a PDF of this presentation?
Yeah, sure.
Because I said huge amount of material. Could it be?
We're on camera as we speak, so this will be on the
No, but I mean the PDF.
Yeah, we can put the PDF on one. Yeah, no problem. So this is a lot. This is just, a sample clause that is probably, if anything, possibly overkill, but that's what we do. You see it reflects market conditions. It repeatedly says it's not going to be renewed. It's, very particular about it. Yes.
Did anyone ever challenge market conditions?
Not that I know of. Not for this purpose. Not that I'm aware of, but I looked at a lot of cases on preferential rents before I came here today. So that's a sample of these provisions, very heavy. It includes increases to the security deposit, pretty much everything you want, which I can circulate as well. But again, to me, the record keeping is really the biggest thing there. So for those of you who may or may not be familiar, one of the, just generally, this is the ETPA lease addenda. So I want to tell you that and I'll show you later, DHCR's website gives you these things, and I'll show you why you have to be careful. This is the one for ETPA, which is not New York City. But it's weird because it says Emergency Detection, if you see all the way at the top, Emergency Tenant Protection Act Standard Lease Addenda for rent stabilized tenants. They have a separate one that's for rent stabilized tenants in New York City. This is actually the one for Westchester. I don't know what the difference was, but it was weird. There is a difference on the renewal form between New York City and Westchester. So you want to make sure that you get, Westchester, assuming we're talking about Westchester, and not something in New York City, because there are some subtle differences. So here, this is basically your form. I don't think we're going to go through the whole thing, but I just wanted to point out, they show you your basic rent calculation, your vacancy, and then on the next page is where, I think it's the next page, let's see. Yeah, they have, you see up at the top, the preferential rent. And they have a little asterisk, provision 20, provision 20, what was provision 20, do I remember? No, I don't know provision 20, but there's something in the instructions about it. It's not particularly helpful, I can tell you that, but you look at it if you fill this out. But this, again, this is not enough. So this shows what the preference, shows the tenant, how it was calculated, how you got to the legal regulated rent, what the preference is. But you have to have your own rider with a clause like the one I showed a few minutes ago, saying that it's temporary, it's only for the term of the lease, and it's not going to be continued after that. Otherwise, this becomes permanent. Okay, so that's obviously very important. This is the RTPA. This is your renewal form that we were just talking about a second ago. So somewhere, let's see if I can read it. There's a section for lower rent to be charged, different rent to be charged. There it is. Lower rent to be charged to vendor. So again, you can, and then look, agreement attached. Yes. So you should permanently mark the X box with a yes if you have a preferential rent, and that's going to be your preferential rent rider. At least you may have other things too, but at a minimum, that's going to say that we're charging normal rent, but only for the year or two that this renewal is in play. Okay. Again, if you don't do that, you run into a problem.
I've had experiences with certain government agencies that we allow to rent into apartments where they go, and then they just cross out statements that they don't like. I often wonder, how do they get away with that?
Yeah, I can send it back and tell them they can't have the apartment if they don't agree with your terms. Unless there's something specific about your term that's, is a legal issue. And I don't know I have an idea which agency you might be referring to, but I think you just have to say no. And eventually, if they want the apartment, they'll work it out. One thing on this, just to note, Westchester, it's 120 days before 120 to 190. New York City, it's 150, so that form is different. So if you pull off the wrong questions on the back, you can actually set it out too soon. And that's, needless to say, aggravation you don't need. It's hard to understand what the prejudice would be, but I can tell you I've been in court and had a tenant complaining, well, that they didn't comply. So I only looked at these, a couple of forms, but here, this is my little note on DHCR. So, they kind of show you, right, if you know that Westchester's ETPA, you can see, but if somebody tells you need the RTPA, which is the renewal form, you just go and click on the first one, that's New York City. It's the second one that you want that says ETPA for Westchester. And the same thing with the lease rider that you need. It says it's rent stabilization law is New York City. Emergency Tenant Protection Act is Westchester. So when DHCR says ETPA standard lease addendum for rent stabilized tenant, it's not actually right. So just, if you're getting forms on DHR's website, they have a lot of forms, it's pretty good, but you just gotta, so be careful. That's my main last point is, it's not always as clear as it should be. And believe me, if you use the wrong form, they're not gonna be saying, oh yeah, it's our fault, our bad. They're not gonna be around and they're not gonna wanna have anything to do with it, so.
So when you're sending out a renewal lease 120 days prior to the renewal, and they don't send it back, what's the rule on the automatic?
Okay, that's a good question. There is no automatic.
New York City, Westchester, or?
Anywhere. They had the regulation that said that, DHR had regulation dealing with renewal leases that said, if the tenant didn't send it back, the landlord had two choices, okay? They could go to court on a holdover proceeding, and then there's a separate notice you have to do to comply with the statute, or deem the lease renewed. That's what the regulation said. Well, it turned out it was irrelevant because what happened was the courts got involved. Well, a landlord said, tenant didn't, to give the facts, right? The tenant didn't return the lease. The landlord deemed it renewed, right? The tenant moved out after, say, 4 months, and the landlord sued the tenant saying, hey, you're responsible for another 8 months worth of rent on this apartment. I deemed it renewed. There is another statute that basically says there can't be an automatic renewal. A statute. The deemed renewal clause was a regulation. And basically the court said that DHCR cannot issue that regulation because it contradicts a different statute. And so there is no deemed renewal. So if the tenant does not renew the lease and you accept the rent at whatever rate, the tenant becomes presumably a month-to-month tenant. Or you could just serve the termination notice that's required under whatever provision it is, and then commence a holdover proceeding. So those are your two options. Or, if the tenant doesn't pay the rent, I guess you could bring a non-payment, but...
Does certified mail ever help? Sending out a renewal?
Certified mail ever help? You guys tell me. But I think he's asking if it's more effective. Yes, you have to do it, but does it help? Does anybody do it?
You know what I do? Send them a letter saying you're gonna start showing the fault.
Yeah, we do
Get
that.
their attention.
Yeah.
Okay. That's a good one. You want the evidence anyway, in addition to the requirement, you want a receipt showing you did it, that green card comes back, or a lot of times, I would be willing to bet that a majority of them don't even pick up their certified mail. So the envelope comes back to you, but you have the proof that you sent it. So when the tenant makes a complaint to DHCR saying, I didn't get a renewal, you can pull out the envelope.
Can you have the super deliver the renewal lease to the tenant?
Well, you could do, well, the answer is yes, but not instead of. You still have to follow the rules on the renewal form, which is the mail certified mail. So yeah, you could do it, but don't do it instead. Because the tenant's going to deny ever getting it, even if it's super handy. And remember, you have legal services for United Tenants there on Wednesday night telling all of these special items to the tenants. So, you have to assume that you're going to get, my view is everything you do, you have to assume that sooner or later, if you didn't do it right, somebody's going to get a big idea. And you don't want to be the one making the appellate case law that I was saying before. So that's the worst case scenario. So, other questions?
Yeah, in the case of a tenant that doesn't respond to a certified mailing with an and time goes by and they're in month-to-month status, can you give them a new lease that states, I'm going to give you a preferential rent, and it could be maybe an increase over what they were paying with the rider in there that says this is your legal rent?
So, is your question basically, can you give them a vacancy lease, increase, a different increase, or?
Yes, and what period of time has to go by for them to do it if they're in month-to-month status?
Or is
I
there a
doubt
law?
there's any particular period of time, once or once a month, in terms of if they, so let's say, it's not so much, well, there's two issues. You could take away the preference, you could have done that anyway. So removing the preferential rent's not a problem. That's different than a vacancy increase. I doubt DHCR would, I think if you try to get a vacancy increase, you'd probably get quite overreaching. I would rather see you actually try to, I would more likely suggest, if that's the case, you serve the notice that's required, bring them into court, and try and get rid of them for not signing the lease renewal as a month-to-month tenant, and then lease to a new person to get your vacancy increase. Now, when we go to court, is the judge going to say, I'm signing renewal, whatever, I don't know, but technically, if they haven't done it, you should be able to evict them at that point.
Because there is no vacancy in the first place. There has to be vacancy. Because
Yes,
vacancy.
yes, yes.
And the second thing is, I think you have to serve a 10-day notice. Most leases will have a 10-day notice to cure before you serve a termination notice.
That's true, but with the non-renewal of lease, it's a little different. You actually have to give a 15-day notice because that's in the statute, whereas even though the lease is expired. So if you have a free market tenant, just to kind of, for comparison, free market tenant, the lease expires. You don't have to give a 10-day notice. At that point, you could just go right to court because the lease has expired on the free market, and that's it. If it's an ATBA tenant, even though the lease expired, you have to give this special 15-day notice that's required under the statute, and once you give that notice, you can proceed to court on the renewal. Yes? Right. Where's the? Oh, if the tenant moves out. Oh, vacancies? So vacancy lease is whatever lease your standard lease is. Except that you do need to attach, this is the form that gets attached to the vacancy lease. But yeah, not a special lease. Yes?
Is there a lease that you recommend?
I don't use the Bloomberg leases generally. The real estate board of New York lease is pretty good. But there are a lot of them, to be honest. And I think that one is decent. It's been interpreted by courts a lot.
Why don't you use one?
Because we have our own lease. We wrote our own. I don't use standard forms myself.
Bloomberg has got
Right. You also have to be, the thing with the Bloomberg leases is, you do have to be careful. I mean, they have so many forms, and some of them are more tenant oriented. Well, I have one in my office actually. I've only had to use it. I've only had the opportunity to use it once, but I literally have it in a folder, tenant oriented, tenant lease basically, and it's one of the Bloomberg forms, and it's awful for landlords. So I hesitate just because if somebody doesn't really know what they're looking at, they use the Bloomberg lease that they got from somebody else, so you really have to go through the lease and make sure it says what you want it to say, or have your lawyer go through the lawyer. Yes.
One thing you have to be careful with, and correct me if I'm wrong, because I actually had make action against you. If you institute whatever lease and rent the last apartment, you can't go change the lease on the renewal. It is what it is, you're married.
Right.
So you,
But the tenant still.
for that tenant, so
Right, no, I
don't
understand.
change,
You're right. Yeah.
you can't change any lease for that tenant.
I understand.
It's stuck, it's stick. You can't, no addendum, no writing, no nothing.
So is your lease on your website downloaded for a fee?
Not quite. We did have a case in White Plains City Court where it was clearly a rent stabilized tenant. We all agreed it was a rent stabilized tenant, and nobody could find the actual lease.
I have that.
And well, it wasn't for you that we had this.
I know, so what happened?
I know that, I don't remember exactly, but we somehow resolved it with, I think, we insisted that they sign off on ours, and somehow it got worked out, but they wanted legal services on it, and they submitted a lease saying that, oh, you have to go with a standard lease, and they had a lease, this is a standard lease. And I was like, that's not a standard lease, we're not doing that. I think we ultimately got resolved where they signed our lease because they wanted to stay and there were other issues. But yeah, I mean, that just goes back to record keeping. That tenant had been there for a very long time. You know, it's a bigger issue if people transfer buildings and they don't get the tenant files on the private building. That gets into a whole other discussion. But that's when we see that problem mostly. Tenants who've been there a long time, the building's been transferred more than once, and somehow the record is lost.
Carl, something that I might wonder, the question, so which I haven't asked the question. I guess it's indirectly tied into all this when there are MCIs and we eventually work their way into rent. But I think one of the big things that has hit this industry, maybe more in the city, but it has to appear, is our beloved governor creating this tenant protection TPU goon squad. And that's what they are. They harass owners who have previously been approved of MCI. So I guess if you want to address that a little bit and the importance of keeping scrupulous records, and I think in answer to John's question, you said you have to get the tenants in place, you got to get their approval. Keep scrupulous records because as sure as God made apples, you will be hit with a review, as I know some members of ours have thoroughly unjustified, and have you go through the whole rigmarole over here are my costs, and here are the special breakdowns you wanted that weren't required before. So you may want to just address that to give everybody a heads up. So one of the TPU is still hot heavy.
When we joined in, worked with the Rent Stabilization Association in a lawsuit against DHCR in New York State and the TPU. One of the issues, there were a whole bunch, but the exceptions to the 4-year rule that I mentioned before. Now, there are a handful of cases that provided exceptions. The court looked at it and said, well, you need an exception for this and you need an exception for that. When the TPU and DHCR, this was DHCR, looked at the exceptions, they said, okay, we're promulgating new regulations and we are going to include those exceptions in the regulations. That doesn't really sound so bad in the sense that the exceptions were already out there in the cases. But one of the arguments we had is that what DHCR wrote in the regulations was different and broader exceptions than what the courts had decided. So these exceptions, they kind of expand. It starts as a narrow exception, and then another case makes it a little wider, and then DHCR gets a hold of it and makes a regulation, and that makes it a little broader. And so with all these exceptions, hopefully you don't have to deal with it. But if you do have to deal with it, it means you really got to have the records, and you got to have them for more than 4 years. I mean, the reality is that you cannot rely on the 4-year rule to protect you really from, the need to keep scrupulous records. So that's an ongoing battle, and it can't be emphasized enough, really.
The cases that come to our attention, I mean, clearly pure harassment, that was otherwise okayed and stamped and approved by DHCR. Now they get, as per Cuomo's order, that's all it is, to make points for the tenant votes and lobbying. They've hit owners hard, asking them for new calculations, a new breakdown for them that never figured into the original MCI application before.
Well, they also use that. They have statistics, and they say, well, we got this many apartments back into stabilization, or we got this much money back for tenants.
This
so
many MCI
even when you settle, right, so even when you resolve something with them, and then they've got a gun to your head, because if you don't resolve it, trouble damages and this and that. So, they consider it, it feeds into their statistics. Like if you're you have a risk of trouble damage and everything else, so you give them back $20 just to get out of the whole thing, and then DHR chalks it up as a big victory, on their statistics. And so,
Which has a political implication, because the tenant lobbies and the tenant will see that and say, oh, boy, he's on our side, whatever, let's do that. Just be careful. Just be careful.
somebody wanted to, any other questions? Somebody wanted to ask me about dogs. Still want to ask me about dogs? Yeah, go ahead.
Yeah, I wrote 3 letters to George Vladimir to explain from the dogs.
Please.
Pardon me?
What, I'm sorry, anything?
I wrote 3 letters to George Vladimir regarding comfort dogs to explain what the definition is of a comfort dog.
So you're talking about
Therapy dogs.
Animals or therapy dogs?
Yeah.
So,
Because I have lots of
as I'm fond of saying, and you've probably heard it before, so forgive me, but the cat is out of the bag on dogs. You cannot, it is a big problem. We could do another thing on pets and especially dogs, but the reality is that if somebody is entitled to an accommodation because they have a disability and it interferes with their use and enjoyment of the apartment, and they need an emotional support animal because they have whatever condition, you have to give it to them. That having been said, there are steps that can be provided to a tenant requesting such an accommodation. So you give them, we recommend a set of questions for them and for their physician or whoever it is, and ask them to fill out these forms to see, at least to make sure that they really do meet the criteria for this accommodation. And I can say that although it's not often, and sometimes what happens is you tell them that what they provided is inadequate, and then they go back and they make it adequate. They get a better letter from their doctor or whatever. But there are times when we've looked at it and said to somebody, this doesn't qualify. You don't need the dog in your apartment, and they go away. That's happening less and less where where it's over now, because you can search the internet and get a phone. What I imagine is, I've never done it, but I've seen the ads on the internet. They must conference on the phone with the person from California, and they prescribe them the dog. So it's very, very difficult, especially with no dog buildings, because if she has a dog, why can't I have a dog? And it becomes difficult. But I think it's there are things to be done. You can't even, there's a HUD opinion from, I think, 2014, 15, 16, you can't regulate the size of the dog, you can't regulate the breed of the dog. If they have a right to that dog, they can basically just give it up. They got the dog, and that's it.
Why does it have to be a dog?
It doesn't, but the dogs are the ones that...
Well, no, but someone came to me asking for a comfort dog, and I said, do you have a comfort cat? And I never heard back from them.
Well, it's a good answer, and if they buy it, I think it's fine.
Yeah.
You can't regulate, if DHR said you can't regulate the breed of the dog, I'm willing to bet they can say you can't regulate the type of the pet. And typically, the letters from the physicians do require dogs. I mean, oftentimes cats, are not as supportive in my limited experience with cats. Yes?
Well, our case, I think our case, but we have a little anomaly, because our building allows dogs, but they only allow one dog. So we have a resident that has a dog, but then got a second dog, we got a letter, you're not allowed to have 2 dogs, only one. The second dog is now the therapy dog.
I mean, I will tell you that I think that's probably questionable. All these things depend on how far you want to take them. In a building where you're already allowing dogs, it becomes diminishing returns. In a building where you're not allowing dogs, it's a different issue. So I will say that we did, it's not exactly similar, but we had a case about 2 years ago, and people wanted to have, husband and wife, claimed that they were both disabled, and they needed, therefore, 2 handicap parking spaces. Okay? Now, they had one. They actually had a garage space, and this building didn't have a lot of garage spaces, so they had a close garage space, and they wanted a second space. Now, the building only barely had enough of one space per shareholder. So our question was, our position was that a second space, if everybody else only had one space, wouldn't just give them the same usability of their apartment, it would put them in a better position than anybody else. And they sued us in federal court, and we actually got the case dismissed. The judge agreed with us that 2 parking spaces was not a reasonable accommodation. So a judge might agree that 2 dogs is not a reasonable accommodation. But you have to go to court to find that out.
Well, I mean, dogs, there is no such thing as comfort dog. There's no like training that they go through or anything. So if they already have a dog, then that would qualify as the one comfort dog.
I would think. But the only way to find out, the only way to truly get to the bottom of it is to get sued, basically, right? Bring a lawsuit and end up in federal court. So yeah, I don't remember. I mean, I don't know. I don't really know the specifics about your situation. I know generally. So I mean, nobody wants to find out because they're in court or before human rights or whatever. But we've won cases about dogs and human rights, but it's hard. The human rights, the Fair Housing Act, the Americans with Disabilities Act, these cases, the deck is stacked a little bit, I think, at this point, certainly on dogs. There are other types of issues, modifications and things of that nature, like the parking space. There are other things. So I wouldn't say that you should assume that because somebody requests an accommodation that they're entitled to it. I mean, you really have to look carefully at it, and I think it's important to do that and to get the backup documentation and make a determination, because otherwise, depending on what it is, you'll just get more and more requests of the same thing. And, it can be disadvantageous to some of your other tenants. Yes?
The point that I like to have cleared up is the rights of the other tenants who don't have dogs or are afraid of dogs or are allergic to dogs. And now that the dog is smart enough,
I don't think there's...
It's definitely afraid of dogs. And what do I do?
You have 2 disabilities, and then you go back without before.
I think, I mean, you're not able to say, I don't, it would be hard to say, this comes up pretty much almost only in neighborhood buildings. But yeah, I mean, I think you're hard pressed to say no to somebody with a disability who's entitled to the dog because somebody else in the building is scared of dogs. And if their fear of dogs rises to the level of disabilities, then maybe they need to do something. Or worst case scenario, you all end up in court together.
Is there a limit to the pet fee that you can charge, or is there a pet fee?
You can't charge a pet fee for an animal that's there as an accommodation because it's not a pet. It's an accommodation to your policy. Yeah, you can't do pet rent.
Can you keep them out of basements and laundry rooms? Require the dogs just to go from the apartment and out?
Probably difficult if the person needs the dog, but depending on what the restriction is. I mean, we had something, not exactly that, but the person wanted to walk the dog, here, and we wanted them to walk the dog there. So, we gave them the accommodation for the dog, and then it was where they're going to walk the dog. And Division of Human Rights, I live in New York State, actually agreed with us that we could require the dog to be walked here versus here. And they said it wasn't a material difference in distance or whatever. So there is some basis for reasonable, restrictions.
Can I ask you a non-regulated rent question?
Yeah, sure.
If in a co-op, the co-op allows rentals. So if the board decides that the rental, say, year is up, and they don't want to renew the lease, can the renter sue the owner of the apartment and subsequently sue the board? Is there any recourse to the tenant has, or is the board, the renter still have privacy over everything they do? Will the law change it?
I don't think there's any change in the law relative to that. The board should have discretion. I mean, the only thing that's not clear to me is what was in the lease, what was in the initial approval, that type of thing. But I wouldn't typically, I would not think that would be an issue for the board to be concerned about, or overly concerned about.
Carl, getting back to the question that was asked about other ways you can reasonably limit where a dog has access to. Now, it seems to me that, again, I'm an attorney, so it seems to me that a co-op board, in the interest of concerns for public health or sanitation, whatever, might be able to differentiate with reason, certain limits, the person doesn't have to take the dog to the laundry room, do their laundry, and dry it and take it back to their unit. Would a health or common safety, or however one wants to characterize it, wouldn't that hold sway that you're not singling out anybody in particular, but certain places should be off limits to anybody but humans?
Maybe, but to be honest, people are bringing them on planes. They're bringing them to court now. People bring their dogs into court. I mean,
Linda Rosenthal down in Manhattan, she pushed through a bill that personally I think is disgusting, and I love dogs. That they bring dogs to a public eatery, and they can sit with you, and I think it's al fresco, it's not inside the restaurant, but nevertheless, and the dog can be slobbering over the ketchup and the salt and the pepper or whatever, and God only knows what they're doing at the table, drooling with their saliva, and this mania of accommodating pets, for a certain constituency, I think it's a deal.
It's not substantially different what you're saying than the 90-day rule. You don't know if you don't get into court the 90 days after learning about the pet, or at least before the pet was even openly and notoriously traversed the building. There's a pet lobby out there. I don't know who it is, but they're out there, and they get the ear of your elected officials, and they have an impact. So I think you might be able to put some reasonable restrictions in, but you'd probably have to have a pretty strong situation. One we had a kind of play area where the playground area where the kids were versus an area where the kids weren't. So there was some basis. I would be probably hesitant unless there was a real reason to put those types of restrictions. But you might be able to do it, and you might get away with it. And if they agreed to it and just didn't bring the dogs in the laundry room, then they agree to it. They don't bring the dogs.
Dog dander can cause allergies. As well as the dog dander gets in the laundry room or whatever. I would think that you should say that if the rule that is made with logic and reason and the public benefit and health, that maybe they have a shot at enforcing.
You got a shot. Other dog questions? Cat questions?
Oh, yeah, I mean, you can amend your house rules and we've done that.
What was that? The house rules?
You amend the house rules and say that dogs are not allowed in the laundry rooms. We've had very little problem.
Yeah, I mean, I think you could try it. I don't know, if somebody really wanted to go to bat on it and said, what would it be? It would be, I have this anxiety. The only thing that keeps me calm is the dog. So even when I go out, I still need, the dog with me to do the laundry. Otherwise, I can't do it. I can't do the laundry if I don't have the dog to relax me. That would be the thing, I think. But sometimes people are agreeable with these things too. I mean, there are people who get the dogs and look, you have spectrum. I mean, there's people that get the dog and they get the biggest dog possible, and they march it through the lobby at the busiest time, to make the announcement. And then there are other people. I have a client right now. We agreed, and the owner, the property manager, they're like, we don't even know the dog's there. Whatever the woman is doing, she's not making a thing. Nobody knows. I mean, so there's a spectrum.
You just reminded me of something. In the 1920s, Prohibition, tenants in New York City used to have comfort dogs, St. Bernards. And the thing is, the reason why they were St. Bernards, they had the cask of liquor. So they were actually able to open a speakeasy in their apartment. St. Bernard, and nobody was any of the wrong wives.
get something out of it. Crowd show.
Any other questions?
Thank you for listening to me.